Good afternoon and welcome to the second 32nd seminar of the International PhD in Progress Seminar Series Phase 3, organized by the Global South Network. I'd like to start the session by thanking the organizer of this seminar, Dr. Norman Ryat, who is a lecturer in law at the Leicester Law School and the founder and convener of the Global South Network. My name is Conrad Nyamutata. I'm a senior lecturer in law and the outgoing head of research students for the Center for Law, Justice and Society here at the Faculty of Business Law, the Montfort University. I will be chairing this session. Dr. Patrick Masiyakurima is the discussant for today's session. He is a senior lecturer in law at the City University of London and the University of Aberdeen. Rafaella Ethelonti, sorry if I mispronounced that, is the peer commentator for today's session. She's a PhD candidate at the Leicester Law School, University of Leicester. And last but not least, our guest speaker, Ashton Mufari, who is a law lecturer in Legal Undergraduate Studies at the University of Zimbabwe, is a legal author, law reviewer for the Africa University Faculty of Law Journal, and the Speculum Juris Journal. He's also a PhD student at the University of Zimbabwe. His research focuses on mergers and takeovers. Now, Ashton is going to present his project titled, Is There a Clear Definition of Mergers in Zimbabwe? A Critical Analysis of Innscor Africa and another versus the Competition and Tariff Commission, Supreme Court 22/18. I must confess that I absolutely know very little about this, so I will defer to our discussants and also the peer commentator. Now, Ashton, you have 30 to 35 minutes for the presentation, which will be followed by 5 minutes for comments and questions of the discussant and peer commentator, and then 15 minutes of questions and answer session by attendees. The floor is now yours.
Thank you very much, Doc, for the introductions, and thank you very much for this opportunity. I believe that this is a golden opportunity for me as a PhD student. We get to share ideas. Maybe to just indicate that I am a student at the University of Zimbabwe. I am focusing on designing a legal framework for effective regulation of mergers and acquisitions, and I'm focusing on 3 identified stakeholders that are employees, the community, as well as shareholders. So the topic that I'm going to present on today is not really the major area of study that I'm focusing on, but is just one of the areas, and I also intend to develop this paper so that maybe at some point I'll be able to publish it as a part of the requirements of my current studies. So this paper is a work in progress, and the topic, was said before in introductions, it says, is there a clear definition of mergers in Zimbabwe? A critical analysis of the case of Innscor Africa Limited and Anor versus Competition and Tariff Commission, which is a 2018 decision of the Supreme Court of Zimbabwe. Now, this is how I'm going to make my presentation. I'm going to look at mergers and takeovers. Then I will identify the problem that is under investigation. I'll look at the significance of the study, the methodology that I relied on in gathering the relevant information. I also look at the challenges and the background of the study area, whereby I'll be looking at the background of the case as a whole and the current prevailing competition conditions in Zimbabwe. I also look at the major definition as provided for in terms of Section 2 of the Competition Act, which was the main issue which was placed before the Supreme Court in the case of Innscor. I would then look at the analysis of the judgment, and I would then conclude my presentation. So basically, we have got 2 main statutes that regulate mergers and acquisitions in Zimbabwe, or mergers and takeovers. The first one is the Competition Act, and the second one is the Companies and Other Business Entities Act. The only difference between the two is that the Competition Act is the main act which regulates mergers and acquisitions, but it doesn't provide what we call the merger procedure. And in 2019, the legislature repealed the old Companies Act and brought in the Companies and Other Business Entities Act, and they saw it fit to then introduce the merger procedure as well as the contents of the merger contract. But basically, the main statute which regulates how the mergers and acquisitions processes and other requirements such as notification requirements is the Competition Act. But now we need to also take into consideration the fact that the definition of merger itself has been subject to a lot of debate amongst scholars. As I move on with the discussion, I will look at the various opinions that were issued. I'll also look at what some of the Zimbabwean scholars are saying on the definition of the merger itself. The definition that is provided for in terms of Section 2 of the Competition Act is slightly different with the definition that is provided for in terms of Section 226 of the Companies and Other Business Entities Act, which simply says that a merger is a combination or an amalgamation of two or more companies, and it ends there. But the definition that is provided for in terms of Section 2.1 of the Competition Act now goes into detail to an extent that it provides for some of the types of mergers and acquisitions that are recognizable in terms of Zimbabwean law. Now we have got another issue which has been a subject of debate is whether or not there is a difference between what are called mergers and acquisitions and mergers and takeovers. From my study so far, I've realized that although the Companies and Other Business Entities Act does not adopt the word acquisition itself, I've reached a finding that there is no difference between mergers and acquisitions. Why? Sections 236 to 239 of the Companies and Other Business Entities Act they refer to takeovers. And if you are to look at the language that is adopted within these sections, that language clearly points to the fact that takeovers are acquisitions. Now, the Competition Act does not provide a legislative distinction between mergers and acquisitions. In fact, in defining the word merger, it actually gives acquisitions as one of the types of mergers. Now, this is the problem under investigation. In this study, I'm focusing on an analysis and a critique of the judgment of the Supreme Court. And the problem that comes here is that you will note that in this judgment, the main issue that was there related to the definition of a merger. And both parties both parties made arguments that their cases were supported by the specific provisions of the Act itself, but the main issue related to which rule of interpretation was supposed to be adopted. And we say that parties may fail to notify a notifiable merger due to an incorrect legal interpretation arising from unclear provisions of the statute. So the problem that we have here is that we have got unclear provisions of the statute, and parties may end up having to violate the law because, one, they may not be aware of the correct interpretation which is supposed to be followed. But we also have a different interpretation which was given in that legal opinion which was provided. And this opinion has been relied upon for many years by our Competent and Tariff Commission. It's called the Expert Candidate Africa Limited in mine 1983 Private Limited and Competent and Tariff Commission. It's a 2006 legal opinion, which I got this opinion when I was perusing some of the files at the records office for the Competent and Tariff Commission. And from the discussion that I had, I was actually informed that this is the opinion that has been relied upon by the Competent and Tariff Commission for quite a long time. But now this legal opinion, it was based on a certain statutory rule of interpretation which was rejected by the Supreme Court in the case of Innscor Africa Limited. And as I go on with my presentation, I will then identify the different rules that were applicable in this case. So the point that I'm making here is that there ought to be a clear a definition of the word merger in the Competition Act, so that we remove or we eliminate or reduce the risk of violation of this statute. Was the consequence of violating this statute if a company fails to comply with sections 34 and 35 of the Competition Act, we may have a situation where they may end up being fined, and that would defeat the whole purpose why they made a decision to merge. Now, this is the significance of this paper. I'm simply making an argument that corporate mergers are an important tool for effective restructuring of companies. And in Zimbabwe, the analysis and study that I've done will show that many of these companies embark on mergers and acquisitions so that they can achieve synergic gains because of harsh economic environments that are in Zimbabwe. So the significance of this study is that it seeks to motivate the legislature to clarify the definition of a merger as provided for in terms of section 2(1) of the Competition Act, so that the risks of violating the provisions of section 34, which relates to merger notifications, are at least reduced. Now, this was the methodology that I adopted. This is wholly qualitative research, and it is a wholly desktop in the sense that when I approached the Tariff Commission, they shared some links where I can then access information that is housed within their records office. The main source that I relied upon is the judgment understudy. The reason being that this paper is mainly focused on an analysis of a particular judgment. And of course, I also relied on some of the sources from authors, journal articles, case law, as well as the 2 acts of parliament that I've just highlighted. Now, this is the challenge that these are the challenges that I encountered when I was carrying out this research. The main challenge is the issue of limited literature that is within. From the local writings that I've had sight on, I realized that there's just one prominent author who is called Dr. Ignatius Nzero. He has written on some of the competition issues within the Zimbabwean context, though he has not written specifically focusing on the judgment that is understudied. Then, of course, the issue of the Competition and Tariff Commission records. It does not upload all the information or all the relevant records on its website. If you go to its website now, you'll find that there's a lot of information that is missing. It only uploads those cases of public significance and public relevance. So this was somehow a limitation when I was carrying out this study. But of course, in order to reduce the risk of then hitting a wall and failing to proceed with my research, I then relied on other information that I got during the research. Now, this is the background of the case that is under study. What happened was that the matter was brought before the High Court sometime in 2015. A company called Innscor, which is one of the most prominent companies in Zimbabwe and it's in Southern Africa, actually, acquired a controlling interest in a company called Gary Brand Services. And in terms of the Competition Act and the regulations that are applicable in Zimbabwe, Innscor was supposed to then notify the Competition and Tariff Commission for approval, because that transaction met the threshold, which was then 1.2 million United States dollars. But Innscor did not proceed to notify the Competition and Tariff Commission because it relied on a legal opinion which was given by a prominent advocate in the country. And their argument was that in terms of the definition of merger provided for in terms of section 22, in section 2, subsection 1 of the Competition Act, a conglomerate, even if it meets the prescribed threshold, is not notifiable. The interpretation of section 2(1) was that only vertical and horizontal mergers are notifiable. Conglomerates are not specifically mentioned within that section, so they are not notifiable. That was the argument before the High Court. But the High Court then dismissed this argument on the basis that as we move on, we're going to look at section 2, subsection 1 of the Competition Act, which then provides the words "a or any other person." So the interpretation of the High Court was that the inclusion of the phrase "and any other persons" within the section means that the legislature was aware of the fact that there may be some other transactions that do not qualify as vertical or horizontal merger, so they should fit in there. Now, so when the matter was taken before the High Court ruled in favor of the Commission and Tariff Commission. It applied the purposive approach or the purposive rule of interpretation, and the argument from Innscor was they relied upon the justem generis and the nostra associs rule. It simply provides that if you mention one of the items, the exclusion of the other means that the intention of the legislature there is not to include the one that is not mentioned. Now, so this was basically the background of the case, and as I look at the definition of the merger here, I'm now focusing on the decision of the Supreme Court. Both Innscor then took the matter to the Supreme Court. So in terms of section 2(1) of the Competition Act, which was really the center of the dispute in the Supreme Court, a merger is defined as a direct or indirect acquisition or establishment of a controlling interest. The underlining is my own, because it's one of those areas that I then had to focus on when I was now analyzing the judgment. And a controlling interest by one or more persons in the whole or part of the business of a competitor, supplier, customer, or other person. Now, if we are to look at the underlined words, competitor, supplier, or customer, those two, if there is an amalgamation or if there is an acquisition between competitor, supplier, and customer, the type of the transaction that will come up there is either a horizontal or a vertical merger. Conglomerates are not included there because of the nature of the characteristics of conglomerates. Now, this is the basis why Innscor made an argument that conglomerates must not be included there, because the nature of the transactions that are provided for in terms of that section, if I to look at the words competitor, supplier, and customer, they do not include a conglomerate. But by then the Supreme Court, the High Court and the Supreme Court said that no, the fact that they say or any other person simply means that conglomerates are also included there. But there are some weaknesses that are then identified with the reasoning of the Supreme Court, which I'm going to address as I move on. Now, the issue of the Supreme Court was really whether or not a conglomerate which was formed between Innscor and the entity that I mentioned earlier on was a merger in terms of the Act. And if that transaction was then determined to be a merger, then it was then notifiable in terms of section 34 of the Competition Act. So the issue there, if we were to look at the arguments that were placed before the court, the dispute was which rule of statutory interpretation was supposed to be applied. But the argument that I'm making is that due to the importance of mergers and acquisitions in an economy, and also due to the fact that majority of companies in Zimbabwe are merging because of the economic hardships that are currently prevailing, we cannot afford to have a definition having to be subjected to various possible interpretations. The legislature ought to have come up with a definite definition, something that is accurate, so that it cannot be subjected to rules of statutory interpretation, because from my studies, I've realized that these rules of statutory interpretation are not cast in stone. It all depends on who is sitting in judgment, who is deciding a particular matter. Now, if this court prefers a different rule of approach, then that means that that word measure can be subjected to various interpretations. Now, like I indicated, the Competition and Tariff Commission relied on the literal or the purposive approach, and Innscor moved the court to follow the wisdom or the nocita associates rule to ascertain the meaning of the words or other person, which were subject of debate before the Supreme Court. Now, when I was analyzing this judgment, as I said, this is a work in progress. When I was analyzing this judgment, these are some of the issues that I've managed to pick. So the court in this, the Supreme Court acknowledged that there are three types of measures recognized under competition law, and it went ahead and mentioned vertical, horizontal, and conglomerate measures. Now, the court did not even attempt to analyze the definition itself to say that this definition, if I were to look at it wholesomely, it includes an acquisition as a type of or as a type of measures. It also held that vertical measures, those measures that take place between two related companies, as in case of a customer merging with the suppliers. It also dealt with horizontal measures, because from the definition there's that word, there are those words, supplier, customer, or competitor. But now, when it was now explaining conglomerate measures, it did not provide whether conglomerate measures are mentioned within the section itself, that is section 2.1. Now, the court did not deal with the consequences of such measures, which I believe is one of the weaknesses. It was not enough for the court to simply say that at our law, we simply identify measures as vertical, horizontal, and conglomerate measures. It ought to have gone further and look at the consequences themselves, because remember, this was the main issue which was before the court, the definition of the measure and the types of measures. So it ought to have looked at the definition, one, which it did, and it also ought to have looked at the consequence of these types of measures to say, if you are saying that this is a horizontal measure, what are the legal consequences that follow vis-a-vis section 34 of the Competition Act? Now, the interpretation that was adopted, like I said, it was a purposive approach, or the literal approach, where it looked at the preamble to the act, and it held that the main reason why the legislature came up with such a definition is that they want to protect and promote as well as to maintain competition in Zimbabwe. So if you were to say that conglomerates are not included there, then that would defeat the purpose of the legislature. But now, my concern is that even if the court provided the reasons why it adopted the literal and the purposive rules of statutory interpretation, the court did not then give the reasons why it rejected the other rules of statutory interpretation as was advocated by Innscor in this case. So it is not enough for the court to simply say that we are going to adopt a purposive approach or the literal approach. We are rejecting the rule that you want us to adopt, but these are the reasons why we are adopting. Is it because maybe adopting that rule was, going to result in absurdity? They even ought to have gone further to say that this is the nature of the absurdity, but the court did not do that. And the argument that I'm making there is that the court missed an opportunity to actually broaden the literature with respect to this area. Now, the court in its findings also held that when we are looking at the word measure, we should be concerned with what is known as a controlling interest. Once we determine that there is a controlling interest, then we should then go further to look at what is the type of the measure. If we establish that there's a controlling interest, then there is a measure. It also held that the definition provided for in terms of section 2.1 is inclusive, it was widened to include all types of measures. And it went further to say that without the words or other persons, the definition of measure would have been exhaustive, as it would apply only to business or undertakings falling within each of the categories specifically stated. The word other describes a person who would not belong to any other categories of persons specifically mentioned. So these were basically the findings of the court. But my concern now is that the court did not deal with the element of control. If you are saying that when you are defining the word establishment of control or acquisition of control in a certain entity, and you then fail to look at what is it that we call control, because it is not, although it is as sort of indicated within the Competition Act, the court ought to have made some comments with respect to that. It was not enough for the court to say that we simply rely on an inquiry on whether or not there's an acquisition of control. Once we establish that there's an acquisition of control, then there's a measure. What is it that we are calling an element of control? Because this is a critical element in the definition of the measure. And from the literature that I have reviewed, we have Zero. It's a 2024 article where he argues that all the essential elements of such a definition of a measure must thus be clearly defined for a framework to be effective. Was one, in the Act itself, the essential elements are not defined. Even in the decision of the Supreme Court, those elements are not defined. And he also goes further to say that the control element is one such critical definitional element, and the fact that is not clearly defined calls for clarity. So we have a situation where the Competition Act itself is not clear with regards to the element of control and the definitional element of the word measure itself. The Supreme Court is then given an opportunity. It simply mentions that we look at the element of control, but it does not go further to look at those elements or those considerations of the element of control. And the court in this case, the argument that I also make is that the court could have even suggested law reform, considering the importance of measures and acquisitions. Once the court made a finding that the Act itself did not define or does not define the elements of control, and it also does not provide or specifically mention the requirements for us to be able to say that this is a conglomerate measure. It only provides for horizontal measures and vertical measures. The court ought to have even suggested for law reform. We've got many Supreme Court decisions where our Supreme Court is advocated for law reform. For example, we've got a case Conrad versus Chawanda, where the Supreme Court indicated that the legislature should actually work on reforming this piece of legislation because it is one, not clear, and it is being subjected to various interpretations, but the court did not make those suggestions, and these are some of the issues that I have identified. But I also go on to look at, if I were to look at the approach that was adopted by the court, it is somehow positive in some respects, because if it had adopted the approach that was advocated by Innscor, you will note that the purpose of the Competition Act itself, if I were to look at the preamble of it, would have been rendered nothing if an approach is advocated by Innscor was to be adopted. So the fact that the court adopted the purposive or the literal approach in this case, it really is something that should be applauded, even though there are different legal perspectives on which approach should be adopted. Now, I think I've reached the end of my presentation. I've looked at firstly the shortfalls in the judgment, and I've also looked at the positive part of that judgment. Thank you very much, and over to you, Chairperson.
Thank you, Ashton. I guess Conrad, are you there?
My apologies.
Right.
No, sorry, I pressed the wrong button. So thank you very much, Ashton, for that very incisive analysis of that judgment. Like I said, I have very little knowledge in this area of law mergers and takeovers, and I will pass on the discussion to our discussant, Mr. Patrick Masiyakurima, and then later on, Rafaella. Patrick, over to you.
All right, thank you very much. Thank you. It was a very fascinating discussion. Of course, I should confess that I read the judgment yesterday. A friend of mine at the Johannesburg bar sent it to me yesterday, and I read it in full. And my initial impression of it was that it was correct, because if one is looking at mergers and acquisitions, one in the competition sphere, one is looking at monopolies in a very, very difficult market like the Zimbabwean one. And of course, when one is looking at mergers in the context of companies, there are additional issues, including shareholder protection, which could be relevant. So I wonder whether in your final paper, you would look at the wider economic analysis in terms of methodology. You could look at law and economics of measures, because if you do, you will find that perhaps in the EU, in the USA, and even in the South African cases that we referred to in the Supreme Court judgment, there is regulation of conglomerate measures. Of course, regulation of these measures is always difficult, because there a competitor is not necessarily eliminated from the scene, but they are still regulated. So perhaps the most profitable methodology would be law and economics. And of course, you would look at the matter comparatively. So I think just looking at it in terms of interpreting words only might not necessarily fit in with the wider policies that at the heart of competition law. So it might be useful on that front. And I also thought that even if one was to apply the use them generis rule or mosquito or asokis or whatever rule of interpretation, I think the purposive approach that was taken in the case itself lends itself to better results. Because then I think the emphasis there was that if we allow a company such as Innscor, I think it's very big, it's in the beverages area, it supplies ready-to-eat food, it owns all sorts of things, and if it was to keep expanding into other vulnerable areas of the economy, then it means prices could go up, because it has a lot of market power. It could get goods quickly and eliminate people in those other areas of the economy. So it's worth perhaps going back and look at these things and then consider whether they have a bearing on what you are doing. In my view, that would be a very important approach. So I think those are the preliminary observations. And I think in terms of measures themselves as well, I think one has to look at them both factually and legally. So there could be a measure even if a person has maybe 15% of the shares of a company, because then they have a lot of control in terms of appointing directors or determining the strategy of the company itself. So one has to really make these distinctions between basic factual control and an outright measure where perhaps the 50 plus 1% is achieved. So all these things perhaps should come out, but I guess they will, and of course you are at the earliest stages of the paper, and gradually, if you look at these other aspects, it will be a very, very fascinating paper which will contribute to the literature in a very serious way. So those are my observations. I may comment further depending on the other questions that
Sure.
that arise.
Thank you.
Thank you very much,
Patrick.
prof. Thank you very much, Dr. Masiyakurima. I really appreciate the wisdom in that area. I'm definitely going to look at it also from a law and economics perspective, as you suggested, and also have a look at what they are doing in the European Union as well as South Africa, like you suggested. Thank you very much.
Yes.
Fantastic. Yes. Now I would like to ask the peer commentator, Rafaella.
Hello. I would like to thank also Mr. Mufari for the so interesting and insightful presentation he gave us and the opportunity offered to us, because I didn't have a great idea of what's happening in Zimbabwe in relation to the competition law field as well, to explore with him this important for the business and competition law fields matter. So thank you very much, and thanks to Mr. Masiyakurima for the comments, because I am a PhD student too, so I'm trying to think how it could help me as well. So just a quick question in order to extract basically the taste that these developments in the competition field have left the business world with. I would like to ask, do you think that the amended definition of mergers from the previous act to the current version and the result of the Innscor case, as well as the, I believe, increased scrutiny of the CTC, and the competition authorities have led large entities, the business conglomerates in Zimbabwe, to a more conservative approach when thinking about proceeding with a merger, for example, for diversifying their activities and increasing their market power or share? Or do you think that this new landscape has left the business confidence unaffected?
Thank you very much, Rafaella, for your comments and also the question. I assume you are referring to the amendment that was done to the Competition Act sometime in 2001.
Yes. For example, the other person you referred to already.
Yes, yes. So basically, the amendment in 2001 was motivated by the fact that there was no clarity with respect to the types of measure, the definition of the measure as a whole. What the definition of the measure that was there before the amendment did not include the words or another person, right? So the definition that we had would only include vertical measures and horizontal measures. But now, because there were some entities that would run away from compliance with Section 34 of the Competition Act, which relates to notification of measures, the legislature saw it fit to then bring in the words or another persons, such that conglomerates can also be accommodated and they will be mandated to notify and comply with the requirements of Section 34 of the Competition Act. So basically, this amendment brought in a sort of, an umbrella approach, a wholesome approach, where we would say any measure or any amalgamation of whatever nature, as long as it meets those the minimum value, which was 1.2 million by then, it has to be notified to the competition authorities. But now the challenge that I have with that, Rafaella, is this: we have a situation where the legislature did not include in specific terms conglomerates measure. It simply says or another person. So just assume that conglomerates also fit in there. But now, with respect to how our Supreme Court has been interpreting the law, you will note that they have actually indicated in some of these judgments that these rules of interpretation are not cast in stone. So we may have a situation where one of the bench, they say that or any other persons does not include conglomerates based on the no-sit associates rule. The specific mention of one thing is the exclusion of the other. You see, so this is the issue that I'm now focusing on. To say that, can we leave section 2(1) the words or other persons like that, or there's really need for us to actually relook at it, which the Supreme Court never suggested. It simply says that we are going to adopt the purposive approach and end there. To make matters worse, it did not then ventilate on why it rejected some other rules, especially on the issue of absurdity that I have indicated. But I do agree with you that the inclusion of the words or other person is now widened. The sort of the umbrella. It is now adopted a certain approach where we simply say all the transactions that are considered or that are deemed to be mergers must be notified as long as they meet certain prescribed threshold. And in terms of its effect to the market, like as indicated by Dr. Masiyakurima, the amendment is really helped. It's just unfortunate that from the year 2001, when the act was amended, the research that I have done so far, I've realized that there are only 2 judgments that have interpreted that section by the Supreme Court. So there's that limited literature that I was looking at, and this is also confirmed by Nzero in his 2024 article, who then advocates that you should, some sort of absence of sufficient judgments interpreting this section are really a limitation when it comes to interpretation of the specific provisions of the Act. I hope I tried to answer that, Rafaella.
Fine, thank you.
Okay, Rafaella, is that all, or do you want to add anything else?
I think I am fine for the moment. I will intervene whenever. Thank you.
Thank you. I have got a question, I think, in the chat from Obet Mawadze, and if Obet wants to come to the microphone to clarify this, that's fine. But it says, don't you think, I'm sure you can access this as well, Ashton. Don't you think if the court had adopted the argument proffered by Innscor, that would have left the conglomerate unregulated? Secondly, from a judicial decision-making perspective, you seem to be making an argument that the court ought to have gone a mile to deal with the element of control. Wouldn't that have led to it making an issue not before it and deciding on it? Third, don't you think the court was concerned with the nature of the dispute before it and the implications of the act of merger of acquisitions and further the regulatory requirement thereof? I don't know whether it's the same question. The word any other person in Section 2 of the Competition Act casts the net wide for purposes of regulation. And what is the issue then? Looking at it from a judicial decision-making perspective, don't you think a different Supreme Court bench can adopt a different rule interpretation system? There's quite a few questions there for you, Ashton. I don't know which ones you'd want to address.
Yeah, thank you very much.
Sorry for the interruption. Can you please stop sharing your screen so that we can see you clearly?
Oh, sorry. Just a minute. I want to plug my laptop. Yeah, thank you. Yeah, thank you very much. I'll proceed to share my screen and then address the questions. Can you confirm you are able to see my screen now?
Or to stop sharing the slides, I think.
Oh, yeah, you're right.
Yes.
If you stop sharing the
You can
slides.
Yeah, to stop sharing the slides so that you see the screen will be more visible for everyone.
Oh, okay.
Yes.
see. How about now?
I can't see any change from my end.
Oh, but I think I can still see you personally, so that I think perhaps you can answer the questions.
Yeah, just proceed.
Yeah,
We can see you,
fine.
but it's not the whole screen, but that shouldn't
Go ahead,
matter.
yeah.
Okay. Yeah, thank you very much, Dr. Nauman. I think Mr. Mawadze has raised quite a number of questions. I'm going to attempt to address each and every one of these. I think in the first part he says that don't you think if the court had adopted the argument proffered by Innscor Africa, that would have left the conglomerate unregulated? Of course, I do agree with that. I do agree with that. And this is the reason why I also indicated that, there are some positives with respect to this judgment. But like I said, Supreme Court sitting there can make decisions that are binding on the High Court and any other lower courts. But now, a different Supreme Court can actually reach a different conclusion because of the rules of interpretation. This bench decided to adopt the purposive approach, and hence it wanted to make sure that conglomerates are regulated. But now there is no hard and fast rule that the purposive approach should always be followed. A different bench can adopt a different rule of interpretation, because remember, these rules are not cast in stone. Then the second aspect is from a judicial decision making perspective. You seem to be making an argument that the court ought to have gone a mile to deal with the element of control, right? I think Mr. Mawa's concern is that the element of control was not an issue before the court, but it was actually an issue before the court. Why? Because the main issue there was the definition of the measure, and the court, in its own words, says whenever we are defining the word measure, let us look at the element of control. So we cannot really separate the element of control from the definition of the measure. So if the court had gone further to look at the element of control, we cannot really say that it would have determined an issue which was not placed before it, because the issue was placed before it, which is mainly the definition of a measure. Then the next part, he says that would that have led to it making an issue before it. I think I've addressed this one. But of course, Mr. Mawadze, you may be of a different opinion on this, but the argument that I'm making in my paper is that the issue of control, it was before the court. I am very much cognizant of the fact that a court of law cannot pronounce on an issue which is not before it. And in this case, I make an argument that the issue was really placed before it, and the court itself acknowledged in its own words to say that whenever we are determining the word measure, we have to look at the element of control. Who controls who? Now, the third part is, don't you think the court was concerned with the nature of dispute before it and the implications of the act of measure of acquisitions and further the regulatory requirements thereof? I'm not sure if I'm getting this question clearly, Mr. Mawadze, but I assume that you mean that the Supreme Court, when it determined this matter, its main concern or interest was the nature of the dispute before it. I think it is also linked to the second question to say that the nature of the dispute before the court was really the definition of measure as provided for in terms of Section 2 of the Competition Act. So really the court dealt with the nature of the dispute, and in dealing with the nature of the dispute which related to the interpretation of the word measure, it then brought in the issue of the element of control. Then the word and another person in Section 2 of the Competition Act casts a net-wide purposes. A net-wide for purposes of regulation, and what is the issue then? Are conglomerates, not persons. I do agree with you, Mr. Mawadze. This is the very reason why the Act was amended in 2001 to bring in the words or another persons. Conglomerates can be any other persons if you adopt the purposive approach. But a different bench may be inclined to adopt a different literal rule of interpretation. If the court is to adopt the nocite associis rule, conglomerates won't be included within that definition. If the court decides to adopt the purposive approach, the literal approach, then conglomerates may be included under the definition of the word major regard being added to the words or any other persons. But the issue there simply remains that if this bench can adopt a particular approach, recognizing that these rules are not hard and fast, and a court is at large to adopt a rule which it wishes, then the law remains unclear there. Why would we want to bring in different approaches, literal rules of interpretation, or on something that is very important like defining a major? We should simply adopt an approach which is certain to say that this is the definition of the major. Why don't we just include the conglomerates, or at least include the elements? I understand that in terms of section 2.1, the Act does not specifically use the words vertical measures or horizontal measures, but it provides the elements. Why didn't the legislature then also provide the elements of conglomerate? Because we are having a situation where a different bench may reach a different finding. And as we are all aware, the Supreme Court is not bound by its own decisions. You can simply wake up and say, we understand that last time we adopted a purposive approach, now we're going to adopt this approach, and it provides reasons. But if the Act is now simply clarified, then we'll make sure that the possibility of a different bench arriving at a different finding is eliminated. I think there's a question from Dr. Masiyakurima.
Microphone is off. So personally, I think the possibility that a different court may arrive at a different conclusion is not necessarily a bad one, because a superior court should be able to address errors in its previous judgments. Of course, it is a standard practice in most jurisdictions that courts can depart from their previous decisions. But I think on this one, if one looks at the economics of mergers and acquisitions and how competition law operates in this area, whether a particular rule of interpretation is used or not, I think the results are likely to be the same. Of course, conglomerates always give rise to numerous problems because there is no perceived competition between the companies that are acquiring each other. But all the other issues relating to control are the same. And of course, I think here in the comments, there is reference to the fact that control could be more than 50%, but it is not necessarily the case. It could be 33% or less, because in large multinational companies, for example, being a controlling shareholder does not require having more than half the shares. It is to do with the wide dispersal of shareholders, and one person with 20% or 10% can make all the decisions. So control is a fact-sensitive matter which does not necessarily equate to having half or more than half of the shares. So that is a point which one would need to clarify. But whether the court makes a different decision or not, I think it's standard practice that a Supreme Court is not bound by its own decisions, because it should be able to correct errors in previous judgments, or perhaps things might have changed significantly in order for it to arrive at a different conclusion. But the basic premise of your research, I think, is very interesting nonetheless.
Okay, thank you very much, Patrick, for that very useful intervention, and also Obed for your very helpful questions. I noticed you've got another question you've added,
Yes.
but unfortunately, we have run out of time, and I'm going to rain on this parade, which actually was very interesting in exchange, which I've found very helpful and educative, at least from my point of view. Obed says you wanted to stay more debate. Yeah, I noticed that, and it's good. And Ashton, thank you so much for coming and presenting such an interesting paper, especially those that are in your field. I can see they were really engaged with the subject, and I wish you all the best with your research. I noticed that your motivation is to, or rather, the reason why you're trying to do this is to motivate the legislature to clarify the definition of merger. I wish you the best of luck with that. So thank you very much. And I also want to thank, of course, Patrick for coming and being the discussant for today. And of course, Rafaella, again, for being the peer commentator, and all of you who have asked questions to Ashton. I want to thank, of course, Norman for organizing these meetings weekly, and we look forward to the next one.
I would just like to say, look after yourself. Have a great day. See you next week. All right.
Thank you
All
very
right.
much.
Bye.
Thank you very much, all
Bye.
of you. Thank you.